Hi, this is Rob Weiner. I'm chair of the ABA section on civil rights and social justice. Welcome to the latest rapid response webinar. It's co-sponsored by the ABA Commission on Immigration, ProBAR, and the Children's Immigration Law Academy. The section of civil rights and social justice is thrilled to be able to partner with our co-sponsors to provide this important training on a really timely issue. During this bar year, our goal is to respond rapidly to government action that affects civil rights and civil liberties by offering webinars and commentary and podcasts and other information. We encourage you to check the section website, which is www.americanbar.org/CRSJ, or our Facebook page or our Twitter handle at ABA_CRSJ for more news and information, replays of our programming. If you like our work, please become a member. During the program, if you're so inclined today, you can ask questions of our panelists by finding the questions box on the right-hand side of the panel and typing in your questions. And we'll be sharing a recording of this program with everyone who is registered so that you can then share it widely with your networks. And please feel free to leave us feedback or ask questions to follow up. Now, today's program is entitled In the Wake of Zero Tolerance, Best Practices for Representing Separated Families and Children. It offers practical skills for attorneys who want to learn more about effectively representing families separated by the administration's zero tolerance policy. Our moderator today is Dalia Castillo-Granados, director of CILA, and she will discuss pending litigation that will determine the future systems for families seeking asylum at the border. She's joined by Jody Goodwin, our very experienced private immigration practitioner who's working on the Texas-Mexico border, and she'll discuss the intersection of immigration enforcement with criminal law and the consequences of the criminalization of asylum seekers. Also, Julie Pash, director of the Adult Detention Project at ProBAR, and she'll discuss the process for parents seeking asylum post-separation, including the credible fear interview and detention. And Megan Johnson-Perez, director of the Children's Project at ProBAR, will discuss the process for children sent to the Office of Refugee Settlement Centers post-separation. But first, we're going to hear from the president of the ABA, Hillary Bass, who has been very outspoken against this the program of our administration and the injustice of separating immigrant families. She has made us all proud by standing up on behalf of the ABA for the rule of law. Hillary, the floor is yours.
Thank you, Rob, and thank you all to the more than 700 people on the line who have volunteered to participate today to learn more about how they can help. Whatever your views on immigration policy, as lawyers, I don't think anyone cannot be concerned about the due process implications of the current crisis on the border. When I was there just a couple of weeks ago and heard from the women at the Port Isabel Detention Center about how they had been separated from their children and how they had been provided no information about what they needed to do to be reunited, I made a personal promise to them that the lawyers of America would not rest until every one of them was reunited with their children. So through this CLE today and through a number of important programs we're going to be holding at our Chicago annual meeting the first week of August, we are going to provide opportunities for our members to engage. And let me just bring to your attention the webpage on the ambar.org/immigration justice site. Again, it's ambar.org/immigration justice. That is a page where you can find out specific programs that the ABA is involved in, how you might be able to participate as a volunteer pro bono lawyer, how you might be able to donate, and how you might be able to advocate. So I hope all of you have an opportunity to take a look at that and make a decision as to how you can personally help to make a difference in this crisis. And now it's my pleasure to turn the program over to Dahlia to introduce the topics that you'll be hearing about today. Dahlia?
Yes, thank you so much. We are really excited about today's program and the panelists that we have who are really on the border and working with this population day to day. First, we're going to start with Jody. She's going to go over the criminalization of asylum seekers at the border. Then we're going to have Julie Pash to talk about the system that the parents are currently in. Megan will talk about the system that the children are in, and we'll finish up with the litigation update. So without further ado, I'll turn it over to Jody.
Good morning. Thank you, Dahlia. Thank you, Hillary. Thank you, Rob. Thank you all for joining us for this session today. Not only is it timely, but it's very important. So my job today is going to be to go over sort of the initial stages of how it is that migrants are treated within the immigration system. And by doing that, it's really important that we start off with a little bit of background. We've put the term a border crisis in quotes for a couple of reasons. It seems as though that there actually really is not a surge in the number of people that are coming. In fact, if you look at the data that Border Patrol keeps with respect to entrance to the United States, we're pretty much at a 4-year low as of 2017. There's been very little movement to increase those numbers since then. And it looks as though that we have a crisis here on the border, but quite frankly, it's a manufactured crisis simply because of the fact that a zero tolerance policy was implemented by the Attorney General. So it's interesting that we should point out that there's over $20 billion with a B dollars spent every year on enforcing immigration law, and it's the largest budget of any law enforcement agency in the United States that goes into Border Patrol and ICE. So there's huge amounts of money that are going into to enforcing the immigration laws. And quite frankly, if we look at things from a logical standpoint, there may be other ways that we can use smarter enforcement at the border than the zero tolerance policy that was implemented recently. So let me tell you a little bit about who's coming. Primarily, we're seeing with the zero tolerance policy individuals from Central America that are being prosecuted. So those individuals are coming from the Northern Triangle of Central America, largely Honduras, Guatemala, and El Salvador. And if you know anything about the history of those countries, they're fleeing uncontrollable violence. Many women are fleeing domestic violence, sexual violence, lots of gang violence. There's numerous areas within all three of those countries where we could qualify the government as a failed state because they're unable to be able to enforce laws or have effective law enforcement. There are 2 cities within those 2 countries that have the highest murder rates in the entire world. It's not as though these individuals are mere economic migrants. They're seriously fleeing horrific violence, and that's why they come to the United States to be able to seek protection. There is a guarantee within U.S. immigration law as well as international law that every person who comes to the United States, whether they enter at a port of entry or if they enter between ports of entry coming through the Rio Grande River or coming through the mountains or deserts of Arizona, New Mexico, they also have the right to apply for asylum, and that is a right that's protected by statute. So what happens? We have lots of Central Americans. We do not have a crisis in terms of numbers, but we have a manufactured crisis that was started because of the zero tolerance policy. So we'll move to the next slide and let's talk about that zero tolerance policy. So the zero tolerance policy basically was rolled out when the Attorney General made his announcement in April of this year. He announced that there would be a new zero tolerance policy for individuals that enter the United States unlawfully. So what that means is that everyone that the Border Patrol apprehended, if they had crossed through between ports of entry, would be prosecuted for the offense of unlawful entry. And that announcement in April was followed up by implementation the beginning of May. In May, the Attorney General, in collaboration both with the Department of Justice through the U.S. Attorney's offices and the Department of Homeland Security with the cooperation of the Border Patrol, began prosecuting anyone that was picked up between ports of entry. Now, I can tell you anecdotally, being here on the border and seeing those prosecutions as they ramped up, that initially the Border Patrol did not send everyone. So it wasn't a true zero tolerance policy because there were severe concerns with respect to capacity to be able to handle the workload. It's estimated that they were approximately sent about 60% of the individuals that were apprehended actually to be prosecuted. But what I can tell you is that before this zero tolerance policy, the number of individuals that were sent for prosecution was much less because the U.S. Attorney's Office had guidelines with respect to who they would prosecute. And generally that meant it would be individuals that had had multiple entries into the United States, or it would be individuals that had any type of criminal history. We never saw asylum seekers in court being prosecuted for illegal entry. Because the law allows those asylum seekers the right to seek asylum, this was all too new to be able to see asylum seekers in court. What this meant when they started prosecuting individuals is there was a fiction that was created that because they were being prosecuted, if you had entered as a family unit, the children could not be taken to criminal court because they had to be transferred over to the U.S. Marshal's custody, and the U.S. Marshals does not hold children. So that's why the separation began. Because of the prosecutions, the parents had to be separated from their children. And I'll just take a brief digress here. I don't think that they necessarily had to be separated. I do think the separation was done intentionally to be used as a deterrent. The individuals actually are never physically transferred into U.S. Marshal custody, even though they're prosecuted. They're simply taken on a transport bus from the Border Patrol facilities to the federal court. And I can tell you that more than 95% of the individuals that are prosecuted are given time served, and the time served is the amount of time that they've been in Border Patrol custody. So the whole process to take them from the Border Patrol station to the federal court, go through the prosecution and sentence, and back to the Border Patrol station is probably a total of about 4 or 5 hours. But instead of just having the children wait for their parents to come back from court, during the time that the parents get taken to court, the children are swiftly taken out of the Border Patrol processing facilities and transferred away, thus creating the separation. So I think there was a way that they could do it without having to separate all the parents, but that's not how it worked out. So because of the separation, you're all very well aware of the public outcry and outrage over the fact that the children have been torn apart from their parents, and then there's been no real plan or organization to be able to get the children back. And I think as a direct result of not only the outcry on the part of lawyers around the country, the press, the media, as well as citizenry in general, on January 20th, that's when President Trump signed an executive order ending the family separation. But effectively what that order meant is that no longer would family units with the parents be sent for prosecution. So it leaves zero tolerance intact except for the family units. Let's go to the next slide, and I just want to talk to you a bit about process and sort of what happens, okay? So here along the border, I think that it is best to sort of describe things with a chronology. So if someone crosses the border, they'll be apprehended by Border Patrol, and if they cross the border at a lawful port of entry, they'll still be apprehended by the Border Patrol. So it matters not whether they've crossed unlawfully or lawfully at a port of entry. They will be apprehended and taken into custody. Once they're taken into custody, they'll be transferred to a Border Patrol station. And if you're looking at the slide on your screen right now, the picture on the left-hand side is a picture of the Border Patrol Central Processing Facility that is inside a Border Patrol station. So this is where the Border Patrol agents would actually question the individuals, get information about their biographics and their background, and actually prepare the arrest report, which for immigration lawyers, we call it the I-213. It's the apprehension report. And this is where they also will make the determination to expeditedly remove the individual, and that's one process they can go through, or they can decide to issue that individual a notice to appear. And I can tell you that most individuals, especially from Central America, are going to be issued that expedited removal. After they're at the Border Patrol station and they're processed, like you can see in that left-hand picture, many times they have to wait at the Border Patrol station for a number of days. The picture on the right-hand side of your screen right now is a picture of a holding cell at one of the Border Patrol facilities. So this is an actual Border Patrol station. This is not a detention center. This is simply a holding cell at the station. And if you follow the news, this picture on the right is a picture of a hielera. So in Spanish, that would mean, in English, that would mean freezer. So the rooms that they refer to as the hieleras, that's pictured on your right-hand side right now. After they get transferred from the Border Patrol station to the Central Processing Facility, which is a warehouse facility that's in McAllen, Texas, that's commonly referred to in Spanish as the perrera, roughly translated to English as the dog pound. And the reason it got the name dog pound is because it is a warehouse facility where the holding cells are actually made out of chain link fencing. So it looks as though they are cages, just like you might find at an animal shelter. So in Spanish, they often refer to it as the perrera. And those two words are really important if you practice in this area, because many of the questions that you need to ask your clients about what happened to them while they were in custody, they will refer to themselves sort of spatially where they were located at that time. So when you hear the word hielera, you'll know they're at a Border Patrol station. And if you hear the word perrera, you'll know they're at the Central Processing Warehouse. So let's go ahead and flip to the next slide. So what happens after initial processing? And this really comes down to sort of taking a look back how it was before we had zero tolerance and then how it was during zero tolerance. So before we had zero tolerance, the family units would be processed together. And the mothers and children, so if it was a family unit that was a mother and her children, they could be transferred into ICE custody together, because we do have family facilities that can hold mothers and their children. Or the mothers and their children could be released by Border Patrol, and most often they would put them on an ankle monitor if they decided to release them. We're having the issue now that all of the family facilities are at capacity, and they continue to be at capacity. It's a revolving door capacity. So Dilley is a family detention facility, Carnes is one, and then there's also one in Pennsylvania in Berks. The mothers and the children go to those facilities. Unfortunately, if you come and you are a father that is bringing your child, you will not have the luxury of being able to be detained with your child, but the fathers would be detained separately from the children. The children would then be designated as unaccompanied minors and held by ORR. That's not much changed after zero tolerance because there's no place to hold fathers and children together. What we have been seeing anecdotally on the border is that Border Patrol is releasing on an ankle monitor many of the family units that contain fathers and children. So each day we see lots of releases of fathers with ankle monitors and their young children. So let's turn to the next slide and just talk about after the zero tolerance policy. So while we had the family separation going on, what would happen is that once the family units were at the Border Patrol station, most of them were separated from their children at the time of apprehension. So that picture that you saw earlier of the hielera, what would happen is they would have the mother be put in one hielera, and then the children would be put in a different holding cell across the way from the mother, and they would be held there for several days before they got taken to central processing. So I would say about 80% of the mothers that we talked to indicate that they were separated from their children at the Border Patrol station. And then there's another 20%, which tend to be the mothers of younger children, indicate that they were not separated from their children until they went to the central warehouse, which they call the perrera. And the actual point where they are not ever given back their children is when they're transferred from the central processing facility into the marshal's custody via the transport to federal court. So the mothers and fathers, once they're transported to federal court for prosecution, then they are separated from their children, and their children will not be there when they would come back. The children would then be transferred into the custody of ORR, and then ORR has to find placement for those children around the country. Lots of them are down here, but they're scattered out all over California, Florida, New York. They're everywhere. The processing of family units after the June 20th executive order changed in that they no longer would transfer the mothers and fathers to the Marshal Service to be prosecuted for illegal entry. Therefore, they no longer had to separate them. Now, it's up to the Border Patrol whether they hold them for family detention, or in the case of fathers, whether they hold the father for detention and the child goes into ORR custody, or if they release the family unit together with the parent on an ankle monitor. That's how it's working currently. So if we go on to the next slide, I think I want to skip and go over and talk to you about what the origins of the zero tolerance policy are and how it began, and tell you what we've seen in the past. So back in 2005, the original version of zero tolerance was called Operation Streamline. And what Operation Streamline was an objective that was put forth by CBP to refer all individuals that are apprehended within a geographic location for prosecution. So if you took point A to point B on the border, anyone who crossed between those points, they would be referred for prosecution. The idea that Border Patrol had at the time was that every single person that was referred for prosecution would be given a sentence of 90 days. Now, it was a little difficult for me to understand why Border Patrol thought that they could sentence the person because there's a federal judge that was going to be doing the sentencing. And I don't believe that all federal judges went along with the government's desire to have people sentenced to 90 days. In some jurisdictions it did happen, and in other jurisdictions it did not. I can tell you here in the Brownsville division and the McAllen division, we did not see 90-day sentences across the board. We did see sentences that ranged from time served to 10 to 15 days on a regular basis, but very rarely did we see sentences of 90 days. So the prosecution is for misdemeanor unlawful entry, which can be sentenced to up to 6 months in jail. It's considered a petty offense. If there is illegal re-entry, in other words, you've already been deported one time and you're coming back illegally again, you can be prosecuted for illegal re-entry, looking at 2 years in prison. And if you have certain criminal offenses in your history, then you can be looking anywhere from 10 to 20 years in prison for those offenses. Those are felonies, so that takes a different prosecutorial approach than the misdemeanors for illegal entry. So the idea back in 2005 was to deter, obviously, people coming into the United States unlawfully. But what it really did is it created this huge backlog and huge resources in the federal courts, basically skyrocketing the immigration dockets in the federal courts in the Southern District of Texas to where the dockets are about 80% immigration prosecutions at this point, instead of being able to focus on other more serious crimes. So in this next slide, I'm not going to go through this because we've sort of talked through the process, but this is a very handy sort of flow chart for you to be able to go back and look through to understand the steps of what happens when somebody's apprehended by Border Patrol. So the first block is the apprehension for prosecution. Then the middle block is processing. And then the right-hand block is the prosecution's office doing the paperwork to be able to send it to federal court. Then it goes to the U.S. attorneys and their specialized counsel that would prosecute those immigration crimes. You appear before a magistrate judge to be tried and sentenced, usually in the same hearing on one day. And then you're taken back to the marshals if you have to serve any time. If you don't have to serve any time, you skip that step and go right back into immigration custody. That is a nice flow chart so that you can follow through to be able to understand what happens when you're prosecuted under this zero tolerance. So zero tolerance, let's move to the next slide. So zero tolerance has its groundings in Operation Streamline. To understand what it is to have 100% prosecution, we can look back at the data that was collected for Operation Streamline. So what's changed or what's different now is that in this version of zero tolerance, all individuals are being prosecuted, and it is without regard to the fact that they are asylum seekers. We did not see asylum seekers being prosecuted under the Operation Streamline policies. So that is the big change, is that despite the law that allows them to apply for asylum lawfully, they are still being prosecuted for the unlawful entry if they come through at a area that's not a designated port of entry. So after this executive order that we got on June 20th, we have seen almost immediately, it seemed as though the very next day, the Department of Justice was no longer receiving for prosecution family units. So we no longer saw the prosecution of mothers and fathers that were separated from their children. And that has been consistent since June 20th. They still are not taking mothers and fathers for prosecution. And ostensibly, the fact that they were being prosecuted was the reason that the administration pointed to as to why they had to separate them. So they've taken that reason away. So there should not be any separation of families due to prosecutions at this point. However, we are still seeing the separations because of the inability to hold fathers and their children together. So on the next slide, let's talk a little bit about how these hearings work. So Operation Streamline hearings, zero tolerance hearings, they are MASH hearings in federal court. So on any given day, and if you practice criminal law, if you were to walk in on one of these hearings, you would be astonished and amazed at what happens. Most days there's 50 to 70, 80 individuals that are being prosecuted all at one time. So you have an entire room full of individuals in 5-point shackles that stand before the magistrate and are basically initialed, arraigned, pled, and sentenced, all in the span of about 2 hours. They have been able to meet normally with a public defender before this combination hearing where they're tried and sentenced on the same day. But that is something that is very brief, and the public defenders are stretched very thin to be able to have enough time to be able to meet with everyone. Due process concerns all over the place because of the way that the hearings are conducted. There's no individualized hearing whatsoever. The judge sort of goes down the line and asks the same questions to each one of the defendants, and there's a chorus of responses. It's very difficult to determine if there are any particular facts that may mitigate sentencing. There's very little time to be able to go into those type of issues. The public defenders, I have to tell you, if I could throw a huge shout out to the federal public defenders along the southern border. You guys are doing the greatest job ever of triaging and trying to flag those individuals that you can recognize that have a defense or recognize that have mental incompetency issues. And through the course of zero tolerance, the federal public defenders were absolutely instrumental in trying to identify those parents that were being separated, because of course immigration wouldn't give us any type of list of those individuals to be able to follow up with them. So let's just go to this last slide, and then we can move on. The last slide is talking basically about what is the impact of this prosecution in immigration cases. I can tell you that many of the immigrants are very confused with respect to what happens to them in federal court. They don't understand the difference between criminal court and immigration court. They don't understand the difference between the federal judge and an immigration judge. And they're not quite clear what happens to them when they're in the criminal court, and most of them being sentenced to time served, and then they just get sent right back to Border Patrol. They don't understand that that was not a deportation hearing. Now, in other jurisdictions, there's been numerous reports of individuals being requested to sign plea agreements in illegal entry cases, whereby they would give up their rights to apply for asylum, and where they would basically stipulate to a deportation order in return for a plea deal. Fortunately for us, that doesn't happen in the Brownsville Division or McAllen Division, but in other areas of the country where they don't have a significant immigration prosecution rate, we have seen those really horrific plea agreements where they ask you to give up your rights. It's important to note also that if you have a criminal record, including illegal entry or illegal re-entry, it could affect your ability to be able to immigrate in the future. It could affect your ability to be able to get a visa in the future. It can certainly affect your ability to apply for certain waivers. And it can also result in enhanced sentence if you were to come back to the United States unlawfully again. The last slide has some of the language in the questionable plea agreements that we've seen, and you can see that it's very concerning. I'll leave those that slide there so that you can read through that language. But I do want to go ahead and move on from the apprehension prosecution part of things and turn it back over to Dalia so we can start talking about the next steps.
Thank you so much, Jody. And I think now we'll turn it over to Julie to talk about the process for adults.
Thank you, Dalia. So I am going to talk about the process that adult immigrants face after they've been processed by Border Patrol, or sometimes in the cases of what's happening in the Border Patrol facilities. And this is what most of the separated parents have gone through after they've been separated from their children. So the first important thing to note here is that many of these parents, almost all of them in fact, are subject to something called expedited removal. Expedited removal was created by Congress in 1997 for people who were inadmissible at the border because of material misrepresentation, which means that they intentionally provided incorrect information on a visa application or something of that nature, or if they tried to enter the country without proper documents, without a proper visa or another entry document. And this is part of a much larger Immigration Reform Act called, depending on who you speak to, either IRA or IRA. And this says that the government is permitted to order someone removed from the United States without any type of judicial review or judicial process, unless the person intends to apply for asylum or unless they state that they have a fear of persecution in their country of origin. And that's if they come to a port of entry, like Jody was talking about, without a proper visa or entry document, or by statute, if they're physically present in the United States without admission or parole, meaning they haven't been permitted to enter the United States legally. They may be here physically, but they have not been entered. They have not entered from a legal standpoint. Less than 2 years, or if they can't show that they've been continuously present in the United States for the past 2 years. And that is not what is actually in place now, but that is the maximum that the law allows. And the Attorney General has unreviewable discretion to implement this the way that he or she sees fit. So the next slide talks a little bit about the expansion of expedited removal after that initial 1997 creation. So in 2004, the Department of Homeland Security expanded it to include people who were present without admission who were encountered within 100 miles of the southern border who couldn't prove that they had been in the United States continuously for 14 days. So that was not a statutory expansion. That was the Department of Homeland Security expanding it in the law that had already been created by Congress. Soon after, it was expanded to include all borders, so the Canadian borders, also the coast, which are considered under this portion of the law to also be the borders of the United States. And one thing that has happened since the new administration took over is that DHS has also opened the possibility of expanding the way that they are currently implementing expedited removal to cover the full possibility allowed by statute. So right now, what we see is expedited removal is for people who have been picked up within 100 miles of the border within 2 weeks of entry, or people who present at a port of entry without a visa or an entry document. But the DHS memo by then DHS Secretary Kelly permits the Department of Homeland Security to expand that expedited removal to within the full scope of what's permitted by Congress. So that has not happened yet. In order for that to be implemented, a Federal Register notice is published, but it is something that clearly this presidential administration is looking at doing. So one thing that Jody touched on briefly, and that you'll see the statistics on the next slide, is the number of people who have been subject to expedited removal is enormous. This is a population that isn't spoken about all that often. But you'll see, if you look at the very last column for fiscal year of 2016, the total number of removals is under 250,000. 140,000 of those are expedited removals. Those are people who are never going to get to see an immigration judge. In many cases, they're never going to get to meet with a lawyer. They're just, Border Patrol decides that they do not have a right to be in the country, law subject to expedited removal, and they're gone within a couple days. The other category that's present on that chart is reinstatement, which I'll define in a minute, but it's very similar to expedited removal. And you can see, at least for fiscal year 2016, the combination of expedited removal and reinstatement dwarfs in tremendous numbers the number of people who were ordered removed through all other processes. And those other processes are the types of removal that happen in immigration court that of a judge ordering someone deported. There are also something called stipulated removals. If people say that, no, I don't want to fight my case, I'm ready to sign my deportation, they can get what's called a stipulated removal order, or administrative orders of removal, which can be issued by ICE in circumstances where people who are not permanent residents have certain types of criminal histories. So this is a really big population that's subject to expedited removal, and as you can see from this chart over the years, hundreds of thousands of people have been removed from the United States through this process. The next slide shows what the actual 100-mile radius of the border actually looks like on the map of the United States. This is what for the reason of expedited removal and several other reasons, the ACLU terms the Constitution-free zone. If you check out the link that's included on the slide there, they have a good explanation of what that actually means. But almost 2 out of 3 people living in the United States live within that 100-mile border zone. So it covers a really large percentage of the population who, if they have an encounter with Border Patrol or with some other agency, could find themselves subject to expedited removal. So the next thing I want to turn to on the next slide are the consequences of expedited removal. So we already talked about that the person does not generally have access to counsel. The Border Patrol facilities that Jody showed some pictures of earlier are not, it's very, very difficult and in most cases virtually impossible for lawyers to get in there to consult with a client. And for people subject to expedited removal, there's no day in court. They don't have the right to an immigration judge to review their proceedings. It's a decision made by Border Patrol or by ICE, and they're deported. There is a 5-year ban on reentry, so they're not able, after an expedited removal order, people are not able to come back lawfully for 5 years. If they have a prior removal order or an aggravated felony conviction, which is a certain type of criminal conviction in immigration law, it doesn't necessarily need to be aggravated, nor does it necessarily need to be a felony, but certain criminal convictions in the United States qualify as aggravated felonies. And people with those two, one or the other of those qualifications, can be subject to a 20-year ban on coming back lawfully. And then, of course, for most people, the obvious consequence is that they're returned to their country of origin, which can have tremendous, tremendous consequences for people who are afraid of persecution or torture in that country. So the next slide talks briefly about reinstatement. The reinstatement is different from expedited removal, but they really go hand in hand in many respects. So what happens when someone is subject to reinstatement is if they have a previous removal order, deportation order, that was carried out, that was executed. Then when they come back to the United States, DHS is permitted to reinstate that order, meaning that they put the order back in force. There's no new process, there's no new right to see a judge. Just that previous order becomes the thing that the person will be subject to currently. This has also created a problem for many asylum seekers because they are not eligible for asylum if they're subject to reinstatement. This is an issue that's been litigated, and I think is currently being litigated before the circuit courts. But generally speaking, the circuit courts have found that being in the reinstatement process is a bar to asylum. There are other things that you can apply for, but asylum is not permitted for people in reinstatement, generally speaking. So that's and there's a slightly different process. It's very similar to the credible fear process, which we're going to talk about. But people who are in reinstatement, if they express a fear of returning to their country, go through a slightly different system than the people who are first-time entrants or do not have a previous removal order. So the next slide talks a little bit about some of the consequences of expedited removal. And this is from the Immigration Legal Resource Center, and just goes through a bunch of the due process concerns that both Jody and I have spoken about. So things happen really, really quickly. The average length of stay at the Port Isabel Detention Center, which is the detention center served by my organization, is about a day. And the reason for that is because so many of the people there are subject to expedited removal. They stay there for about a day while DHS runs their paperwork, and then they fly back to their countries, or occasionally take a bus back to their countries if they're from Mexico, in a really, really quick setting. There's very little time to prepare in their home countries for them to find access to funds, to find a safe place to stay, or to consult with an attorney and protect their rights while they're in the United States. Another concern that's been noted is the burden of proof, especially with expedited removal for people who don't present at a port of entry but who are caught in the interior of the United States. They need to get out of expedited removal, they need to prove that they've been in the United States for more than 14 days. And I don't know about you, but the kinds of things that I carry sort of with me generally, I'm not sure that I could prove that I've been in the United States for more than 14 days. So should the administration go through with expanding this expedited removal for the full 2-year period, there are a lot of people, more than 2/3 of people, or just about 2/3 of people living in the United States, who will need to be able to demonstrate that they've been here for 2 years. And that's a lot of paperwork to obtain and to carry with you, particularly for people who sometimes have trouble getting official paperwork, like people who are here without documentation. Another concern is the conflict of interest when the the judge and jury, so to speak, is the arresting officer and a law enforcement officer. The likelihood that someone is getting a fair consideration of their claim goes down. There's also, as we talked about, no day in court. They don't get a chance to see a judge or any type of neutral arbiter. No access to counsel. They don't have a right to legal representation for most parts of the expedited removal process. Another thing that's come up quite frequently are huge challenges with how Border Patrol is implementing the screening of people who say that they have a fear. So this was identified back in, I think, 2005 in a congressional report from the International Religious Freedom Group convened by Congress to do a report on this particular issue. And they came to the border, various border facilities, and observed how Border Patrol officers were conducting these interviews. And they noted many times that the officers were marking down incorrect information. They weren't asking these questions at all. They were telling people things like, well, that doesn't qualify you for asylum, so don't bother, things like that. And that was published in a report in 2005, and there was recently an update to that report in, I think, about 2015 that said that basically things have not changed. The Border Patrol is still, in many cases, substituting their own opinions for the opinions of asylum officers who are trained in this, who should be making the determination about whether someone's fear is credible. So I really encourage you, if you're interested in this issue, to take a look at those two reports. I think they're really interesting and heartbreaking reading. But one of the things that they noted, for example, was if you saw the picture that Jody showed a little bit earlier of all the people in the holding facility who are on those little benches right next to each other. One of the things that happens there is that Border Patrol screening. So people end up sitting right next to each other, and they have to talk about why they're afraid to go back to their country to this Border Patrol officer with no privacy. They're right on top of one another. You know, it's a strange government official. So there are significant concerns that people may not be flagged as asylum seekers or someone who has a fear of persecution or torture through this screening process the Border Patrol is not implementing properly. Finally, there's really no safeguard for a mistake in this process. It is very difficult to get someone who enters the United States without authorization to come back to the United States if an error was made. So oftentimes, you know, little errors made by Border Patrol or whoever is involved in the process have huge ramifications, and there's really no way to rectify them. So those are the big issues that ILRC has identified with this process. And I think we've covered a lot of them in many respects. That's definitely concerning. The next slide talks a little bit about how to determine if someone that you're speaking with in an attorney context is subject to expedited removal. So these are just some really basic questions that can be asked to determine whether or not someone might be in that category. So like Jody said, ask about the place that they were in, what happened, how the people that they interacted with were dressed. Border Patrol is always in green. And ask them where they were, if they know, how long they've been in the United States, and whether they've had previous entries or previous removal orders. That way you can figure out whether they might be subject to expedited removal, might be subject to reinstatement, or in some other procedural situation. The U.S. government issues them certain forms. The I-860 would be a notice and order of expedited removal, or the M444 is an information about credible fear interview, and we'll touch on that in a minute. But that is for somebody who is in the expedited removal process but has expressed fear of return. So these are some of the information that you can gather to help you determine whether someone you're speaking to might be in that expedited removal process or subject to reinstatement. So I know that the things that we've been talking about have been really not so positive, but I do want to talk about some of the ways to prevent expedited removal and also some ways to fight it. The most common way to prevent expedited removal for someone who has arrived in the United States is if they claim a fear of persecution or torture in their country of origin. If they express this fear to seek asylum or fear of persecution or torture to Border Patrol or to Immigration and Customs Enforcement, they're supposed to be referred for a credible fear interview. And that's the process that starts their right to seek asylum in the United States. If they are subject to reinstatement of removal, like we talked about, where they have a previous deportation and then a re-entry, they'll receive something called a reasonable fear interview, which is similar in many respects, but for a different group, a different population. Another exception is for unaccompanied children. Megan's going to touch on this, but if a child is under 18, is not entering with a parent or with the legal guardian, and does not have legal status, they're subject to the Trafficking Victims Protection Reauthorization Act, and they cannot be placed in expedited removal. There are a couple other exceptions for status claimants, which are people who claim under oath to be a U.S. citizen, a permanent resident, or people who have already been granted refugee and asylum status and come back into the country and state that to Border Patrol. For visa waiver program entrants, which is a special program for citizens of certain countries who are able to enter the United States without a visa. If they come in and claim asylum, they are not subject to expedited removal. They go through a different process. And there are a couple other exceptions. There is virtually no administrative or judicial review of the expedited removal process itself. By statute, there's no class action litigation. You can file a habeas, but only in very, very limited circumstances. And that's only to determine whether the person filing the habeas is actually an alien to someone who's not a citizen of the United States, whether they were ordered removed pursuant to expedited removal, and whether the person is a permanent resident or is granted refugee and asylum status. So there's virtually no review at the judicial level of the expedited removal process. The next thing I want to talk about is to go through the credible fear interview process. So the credible fear interview is for people in expedited removal who have expressed a fear of return to their country, and it is the first step in the asylum process for people who are subject to this type of expedited removal. So the legal standard is lower than that for asylum. They need to show that they have a significant possibility of establishing eligibility for asylum, withholding of removal, which is something similar to asylum, or relief under the Convention Against Torture, which is another type of legal protection. Historically, the pass rates for the credible fear interviews have been pretty high, in the 80 to 90% range, and that's because this is really just a screening mechanism. This is to make sure that the person meets this minimum threshold to go see an immigration judge and present the full case. I can tell you within the past 2 to 3 weeks, I think that standard has been absolutely fallen apart. We are definitely not seeing 80 to 90% pass rates here on the ground anymore, and there are a couple of reasons for that. But that's what the statute and the regs state the asylum officer is supposed to do. Both people who arrive at a port of entry seeking admission or seeking asylum, so what on the law terms arriving aliens, and people who enter without inspection, so people who cross the border without authorization, are subject to the same credible fear interview process. And it works a little bit differently in different jurisdictions. Different asylum offices have their separate ways of handling it. But the way it works for many of the parents who are detained during this process is that they will come into detention. Usually by that time they've expressed a fear of return. Sometimes they haven't, so they make that expression to ICE. They get told that they're going to have the interview. Locally, it is all done by phone. The asylum office is located in Houston, and they do everything by phone. There is an interpreter present on the phone for all applicants. Sometimes they have difficulty finding some of the less common interpreters for some of the less common languages, but they will provide interpreters for everyone. And the asylum officer will go through a number of basic biographical questions and then start asking them about their claim. The asylum officers are trained in immigration law. They are trained in how to interact and interview with people who have suffered trauma. And they're also trained in general country conditions from many of the refugee-sending countries that they tend to encounter a lot. And these interviews are not supposed to be adversarial, but I can tell you in many situations they feel like they are. But the idea is to get just enough information to see if the person has that significant possibility of establishing eligibility so that they can then be sent on to the immigration judge. The interviews tend to be fairly quick, and they definitely sped up over the past couple months. The people that we see spend about an hour going for the entire process, reading them their rights in the entire process. And it can be very difficult for people who have a fear of return to explain all the details of their claim in that kind of setting, especially when it's moving very, very quickly. For people who are not represented, we notice often that because they do not know what is necessarily the most important elements of their case, and because the asylum officer certainly doesn't know that, important details get left out. The asylum officer doesn't ask the right questions, and the applicant does not have enough information about the law to provide the extra information that they need to really make sure that that interview covers the correct facts. So it's a really challenging process for people in detention without a lawyer in particular. So within usually about 2 weeks of that interview, they'll get the results, and the results can be either positive or negative. If it's positive, meaning that there was a significant possibility that they could establish their eligibility for asylum, they'll receive a notice to appear, which is the charging document in immigration removal proceedings, and they can start to apply for asylum or other relief from removal for which they may qualify. If it is negative, that means that there was no significant possibility, but they do have the right to have an immigration judge review that decision. So it's not the end of the road in that respect, but the immigration judge will look it over and determine whether or not the asylum officer made the correct determination. By statute, that immigration judge review has to happen no later than 7 days after the date of the determination. We have actually seen locally that there's at least one judge who is denying jurisdiction when the asylum officer has filed the documents or ICE has filed the papers late. So that's been an interesting development here over the past week or two. And I mentioned briefly that we've seen the pass rates really tumble over the past couple weeks, and that is, I think in large part due to the decision by Attorney General Sessions in matter of AB, and then also the new asylum officer guidance that was released about a day or two ago, which if you're interested in this, I strongly recommend taking a look at it because it talks a lot about how asylum officers are supposed to adjudicate these claims for people who are fleeing domestic violence and fleeing persecution by gangs in particular, which are two things that were mentioned sort of in the dicta of Sessions' opinion in matter of AB. So that's posing a huge challenge on the ground currently. The next thing I want to talk about are some of the issues around detention for people who are in this process. So by statute, detention is mandatory. There are a few small exceptions while the credible fear process is in place. And then if a person is found not to have a fear until that they are removed from the United States. The credible fear process, like we talked about, moves pretty quickly. It does vary quite a bit, at least locally, depending on volume, and I think the availability of interpreters is always an issue. But it's usually, what we've seen is depending on the situation, but ordinarily about 2 to 4 weeks wait before the interview. Then you've got another 2 weeks to wait after the interview has concluded for the results, and then about 7 days for the IJ review if the results are negative. So the process varies, but it's usually about a month, maybe 2 months, depending on the specific situation. For the credible fear process, an applicant does have the right to consult with an attorney and to have an attorney present during the interview. Every asylum officer handles this a little bit differently, but there are ways for attorneys to submit evidence, make arguments on behalf of their client, to ask the client questions if the asylum officer didn't touch on certain topics, or to otherwise make sure that the person's rights are protected to the extent permitted under this law. So the next slide shows a map of some of the detention centers in Texas. So if you look, one of the ones right on the Mexican border there is Port Isabel, which is the facility that my organization serves. But there are a number of detention facilities, over 300 throughout the United States, although there are not many that regularly hold large numbers of immigrant detainees. It's a lot of county jails that have 1 or 2 beds for ICE. The Port Isabel's capacity is about 1,200, and Texas has a very high number, generally, of immigration detention facilities. But they are spread all across the United States, although many of them are concentrated near the border. And many of them are also in very rural areas, which makes it difficult for detainees to find attorneys. There's one facility that's a four-hour drive from Atlanta, which is difficult to convince attorneys to be able to make that drive with regularity. So that's a real challenge, is access to counsel for people who are detained, not just because of the locations of the facilities, but difficulty obtaining phone calls, difficulty communicating with the outside world. Access to counsel is a huge, huge challenge for people. So the next slide talks a little bit about what happens in terms of detention after the CFI. So if the person passes the credible fear interview, the law states that they shall be detained for further consideration of the application for asylum. But if the result of the interview is positive, they may qualify for release from detention with parole or bond. Parole and bond are two slightly separate processes that are very similar in many respects. Parole is granted by the Department of Homeland Security. Bond is granted either by the Department of Homeland Security or the immigration judge. And up until about maybe 2 years ago, parole after a positive credible fear interview, at least locally, was very common. And that has dropped off significantly for various reasons. But it used to be fairly common that if somebody passed their credible fear interview, they would be paroled out if they were eligible. And that, unfortunately, has since changed. There is litigation pending on this issue. I think there's actually several elements of litigation pending on this issue. But that's been something that we have observed over the past couple of years. So after someone passes their credible fear interview, ICE will make an initial determination of their custody status. And they have a couple different options. So we talked about parole, which is generally release on recognizance with under a slightly different process than release under recognizance for people who are not parole eligible. For the most part, people are not asked to pay any type of bond money. Locally, we have seen people get asked to check in with ICE on orders of supervision fairly regularly. In other places, they'll parole with the ankle monitors or with other types of community supervision requirements. It varies a little bit across the country. ICE can also set a bond. The minimum bond by law is $1,500. We've seen them go up to about $50,000, $55,000. They can get pretty high. But that is money that the detainee pays to ensure that they will come back to their court process. So if they finish their court process and they're either successful or they're deported and go back to their country, they will get that bond money back. There's also an element of the law that provides for mandatory detention for certain people. This is generally applicants who have certain criminal or national security concerns in their background. That's enough to be a webinar all on its own, probably a whole day CLE. But do be aware if you're working with this population that certain criminal or national security concerns could mean someone is subject to mandatory detention. For someone who is eligible for bond, they do have the right to have the immigration judge review ICE's bond determination. And the immigration judge will determine that whether or not the person qualifies for bond and then set the bond amount. What they can do is either raise the bond that's given by ICE, they can lower the bond that's given by ICE, or they can take the bond away entirely. So if you are working on bond cases and you're not familiar with how your local immigration court handles these, I would strongly recommend talking to a local practitioner. In our jurisdiction, we generally start with the ICE officers because they tend to provide lower bonds in most cases than the immigration judges do, but in other jurisdictions where I've practiced, that's not the case. The other thing that's important to note is that the immigration judge can review ICE's bond determination, but it does not work the other way around. The immigration judge's bond determination is not subject to change by ICE. So the next slide talks a little bit about family separation, and Jody's already gone into this in a fair amount of detail. But like we talked about, the families are usually separated while they're still with Border Patrol. The parent is placed in expedited removal, taken to the detention center, the ICE detention facility, and detained while they're waiting for their credible fear or their reasonable fear interview, while the child is in the care of the Office of Refugee Resettlement. What we are seeing on the ground currently, and ProBAR is working with several hundred parents who have been separated from their children, with Jody's help and with the help of many other organizations. But we are seeing some parents who have been passing the credible fear interviews and then been released either on bond, occasionally on their own recognizance. Others are not passing, remaining detained, and many others are being moved to family detention centers so they can be reunified with their children while the process is going on. So the situation on the ground is always changing, but we have seen parents in different stages of the process, and they continue to move through the process currently. All right, so the next slide just has a little bit of a flowchart of what happens for someone seeking asylum. So in pink, we've got the people who come at the port of entry. Blue, we've got the people who enter without inspection, so they cross the border. So both populations will express fear. They'll tell Border Patrol or ICE that they're afraid to return to their country. They'll have their credible fear interview. And if they pass, the people who arrive at the port of entry, people who are termed in law arriving aliens, are in detention, but they have the possibility of parole. The people who have entered without inspection are not generally parole eligible, but they are eligible for release on bond, either from ICE or from the immigration judge. People who do not pass are subject to expedited removal and will be deported. So this is a weird quirk of the law where people who present to the port of entry are not bond eligible, and the immigration judge has no jurisdiction over their custody. And it's difficult to explain to some of the detainees who don't understand why it's created this way, but this is how Congress wrote it. So it is a weird quirk in terms of the differences in custody determination for people who have entered at a port of entry vis-a-vis by crossing the border. So the last slide are just some additional resources that I recommend checking out if you have a few free minutes. There is some really great information here on the credible fear process. The practice advisory on expedited removal orders by the American Immigration Council is fantastic. It's got a lot of background and talks a lot about the process and the different ways that it can and cannot be challenged. The other thing that I didn't have time to add here, just recently got released, was the asylum officer instruction post matter of AB. So if you're interested in this, I really do recommend checking that out. So with that, I will turn it back to Dahlia.
Thank you, Julie. Next is Megan.
Hi, good morning, everybody. I want to start by thanking folks for attending and just say from those of us working on these issues at the border, one of the few uplifting things we've appreciated over the past several weeks is the outpouring of support from around the country of folks who are concerned about the rights of immigrants and asylum seekers. My portion of the presentation will briefly describe the process that the separated children have been subject to as a result of the zero tolerance policy, with the note that things have been changing pretty regularly, and it has been a feature of this manufactured crisis, as Jody said, has been not really knowing what to expect from the government agencies working with these families. Starting with this first slide, you can see the statutory definition of what is an unaccompanied child. Under 18 years of age, no lawful immigration status, and importantly, no parent or legal guardian in the U.S. available to provide care and physical custody. And once a child is identified by immigration authorities as an unaccompanied child, they are subject to a system that is set up to identify somebody with whom they can reside while facing removal proceedings. And built into that system is a number of protections for what these are, which are very vulnerable youths. And sometimes the process is by needs time consuming. Separated children traditionally, as you might be able to see, would not fit into this definition of unaccompanied, but as Jody mentioned, as a result of the government deciding to prosecute adults, it it meant that the children with whom they traveled were deemed unaccompanied at the moment that the parent was no longer available to physically be with them. Moving to the next slide. Just briefly, this again is something that Jody touched on, but it shows the patterns of migration. The lines at the top are total migration, so including adults, families, and children. The blue line shows a spike. That's the year 2014. I'm sure many of you have heard about the influx of unaccompanied children in 2014. The orange line is 2017. That would be the year that this administration took office. And then the red line in the middle is 2018, the current year. And you will see that at this point, we're on sort of trend with the historical norms of migration flow. Down at the bottom, you'll see the numbers of children, unaccompanied children, that have been apprehended at the border in the current year. And you'll see in May and June a spike that we believe is related to the fact that ordinarily children who arrive with their parents would not have been classified as unaccompanied. But as a result of zero tolerance, a number of children who would have otherwise been processed with their parents were deemed unaccompanied. So that's the spike you see in May and to a lesser extent in June. Next slide. These are more photographs of the CBP holding facilities that Jody talked about in some length. This, as has been mentioned, is the place where any individual who's been apprehended by Border Patrol will be processed for their identification paperwork, interviews. They're not by any means in any sort of ideal conditions to be interviewed, as Julie mentioned. And this is where families might be separated here or at the processing warehouses that Jody talked about. Unaccompanied children, so for children who are classified as unaccompanied by DHS, they cannot remain in DHS custody for longer than 72 hours under statute. And during that time, DHS has to refer them to the Office of Refugee Resettlement, who in turn has to find bed space for them. And these holding facilities came into the news back in 2014 because there was a backup in the ORR bed space, meaning they were at capacity. And so children were finding themselves remaining in these types of facilities for longer than the maximum 72 hours. And there has been a number of reports and even litigation around the conditions of detention in these facilities. I do want to point out that they are distinct from detention facilities where the children are taken once they're transferred into ORR custody. On the next slide. This is a map showing, well, it's not an up-to-date map, but it gives a visual depiction of the fact that there are these ORR facilities all over the US. And when children are placed there, it really hasn't, usually has no relation to, where they know somebody in the US who might be the adult that they end up living with during the removal proceedings, but merely, where there's space or where ORR needs to place the children. They are facilities that are run by private nonprofits that contract with the Office of Refugee Resettlement. And you can see in the numbers on the left-hand side in the columns that we had some particularly high numbers of unaccompanied children in 2014 and again in 2016. So briefly, I'll run you through what a child can expect once arriving at ORR. Each child will be assigned a case manager whose primary job is to reunify the child with somebody they know in the United States. Usually in the case of an unaccompanied child, that would be a family member or somebody that the family knows who's an adult in the US. And what the case manager does is identify them and request a number of documents and perhaps background checks for that person and anyone over 18 in their household. What they're trying to do is prove a connection between the child and the adult, and also ensure that if the child's released there, the child will be safe and will be guided by the sponsor to that's what they call the adult that the child's going to live with, that the sponsor knows about the child's immigration proceedings and will assist the child with attending the ongoing proceedings. As a side note, perhaps Dahlia will talk about this a little bit more, but there's a different, potentially a different process that separated children are going to need to go through in order to reconnect with their parent, or they might go through this sponsorship process with somebody other than their parent who is already in the US. Children also are entitled, while they're in ORR care, to a number of services such as medical classes, some legal services, and just as a practice note, everything that ORR makes note of while the child's in detention is available via it's kept in an ORR file, and you can request it through a file request on the ORR website, and the ORR website link is on the last page of this portion of the presentation. And for the children, now on the next slide, I'll talk just briefly about the types of legal services a child is receiving while detained. Most children, as I mentioned, will be detained in ORR custody. The average length of stay is somewhere between 50 and 60 days currently, but most children will be sent to another part of the country to live with a known adult throughout their immigration removal proceedings. And while they're detained, they'll receive sort of basic services, a child-friendly Know Your Rights presentation, and individual legal screening. If they do have to go into court while detained, a legal services provider such as ProBAR would be available to assist them and orient them in court. If there are particular vulnerabilities identified with the child, they may be referred to a child advocate, which is provided by the Young Center, whose job is to determine the best interest of the child. And also organizations like ProBAR provide legal orientation for the prospective sponsors as well, to explain to them what the legal obligations are for the children. The next slide talks about what might happen. As I said, most children are going to reunify. There are some children who are eligible for relief, but for whatever reason do not have reunification option. Maybe their sponsor hasn't passed the background check, or they don't have a sponsor. They might be eligible for a long-term foster care program within the ORR system that will help them integrate into the US because, as I said, they would have some sort of relief from removal and eligibility to remain in the US. Some children will turn 18, at which point they're usually transferred to an DHS, to an adult facility like Port Isabel, and possibly could be released on recognizance. That happens sometimes. Or while they're detained, they will opt to request a voluntary departure from the immigration court, or maybe even a removal. On the next slide. So a few things that I'd like to make note of is something that anyone who works with this population of children understands is trying to figure out what's going on with them and help them unravel the, learn about and make informed decisions about how to go forward in this system is something that takes a lot of time. And on the final slide, you'll get a link, recommendation to a kind report that talks a lot about how this administration has been putting pressure on kids to move more quickly than I think is really what is required to make sure these children are given due process. And then on the family separation front, it's been really difficult to work with children who arrived with their parents, so arrived accompanied, and in part because they are having difficulty engaging with our staff. They're extremely upset, and they don't really have any plans to be apart from the adult they came with. And for the children who are detained, it's been a little bit better over time, but they generally have not been placed into communication with their parent while they're in detention. So there's really not much that we can glean from children in that stage about what has happened to them, why they're here, and what should happen with them. The expectations have been shifting somewhat. I'll defer to Dahlia to talk a little bit more about perhaps the current litigation. But again, I just want to stress that the system that these kids that have been separated have been caught up in was designed for a whole different type of situation, which is that of the unaccompanied children. And with that, I'll pass it to Dahlia.
Thank you so much, Megan. And now we'll finish up in the last few minutes with an update on litigation. I'm sorry that we don't have, it looks like we don't have enough time to answer the questions that were posted, but the last slide does have our contact information if you want to reach out and email us with any questions. So sort of as a recap, the zero tolerance policy is what led to family separation. And as Jody pointed out, there was public outcry, media attention, a lot of national attention on the detention, the separation of parents and children, and the detention of these parents and their children, which did lead to the president signing the executive order on June 20th, ending the policy of family separation. In that same order, he did reiterate the policy of zero tolerance for offenses such as illegal entry and illegal re-entry, and really replaced this policy of family separation with a policy of family detention, which we do not believe is the answer. One of the things that he directs the Attorney General to do in this executive order is to modify the Flores Settlement Agreement. The Flores Settlement Agreement is something that has been in place for a long time. It was signed in 1997, really to protect children from indefinite detention, and also set standards for the custody and detention of children. The plaintiffs in the Flores suit moved to enforce the Flores Settlement Agreement for children that were being placed in family detention centers back in 2015, because even in the last administration, the answer to the wave of Central Americans that were coming across the border was to put families together in detention facilities. And in 2016, the Ninth Circuit held that the Flores Settlement Agreement applied not only to unaccompanied children, but also to accompanied children. And so in the executive order, the president directed the Attorney General to try to modify the Flores Settlement Agreement once again. So the government filed a motion requesting relief from the Florida Settlement Agreement on June 21st, just a day after the executive order. And the Florida Settlement Agreement, in terms of family detention facilities, requires the release of minors from detention within 20 days. So wouldn't, be in line with the policy of indefinite detention for families as set out in the executive order. On July 9th, the court denied the government's motion and stated, "It is apparent that defendant's application is a cynical attempt on an ex parte basis to shift responsibility to the judiciary for over 20 years of congressional inaction and ill-considered executive action that has led to the current stalemate." So that motion was denied, and the government might go on to appeal to the Ninth Circuit. Finally, the last thing I wanted to touch on is the lawsuit on family separation filed by the ACLU back in February. And the lawsuit sought to reunite asylum seekers with their children because even though family separation reached a crisis point at the end of May, or during May, family separation was still going on, has been going on for the past year. The ACLU was doing this for 2 separate asylum seekers, but also asked the court to grant class certification, which the court did at the end of June. And also the court issued a preliminary injunction on that same day, requiring the government to reunify class members with their children under 5 years of age within 14 days, and reunify class members with their children aged 5 years and older within 30 days. The 14-day period expired just a few days ago, and the government was not able to meet the deadline. It had only reunified about half of the under 5-year-olds with their parents, and part of the reason why they were not able, the government wasn't able to reunify, or part of their stated reason was that they had to follow the ORR procedures, which Megan talked about, which includes, might include DNA test, background checks to make sure that the family relation is there, to make sure that the home is safe for the child to be received. But after a status conference, the court issued further declaration that said that the government does not need to comply with all of the TPRA procedures before reunification, or doesn't need to comply with all of the ORR guidelines before reunifying the children. So as Megan mentioned, this is going to be a truncated version of the ORR policies for these under 5-year-olds to be reunited with their parents within 14 days. There is another deadline coming up in about 2 weeks for the kiddos over 5 to be reunified with their parents. As Hillary mentioned at the beginning of the webinar, the American Bar Association does have a landing page on family separation and detention, and it has on there links for ways that you can advocate, volunteer, donate, and learn more. So we encourage everybody to go on here to learn more about this issue. And here we have some volunteer opportunities. The situation at the border, as all of these, all of our panelists have mentioned, is really fluid. They're overwhelmed with the amount of support that they have received from the community, and are excited about this outpouring of support, but really need patience to make sure to manage the volunteers. So we ask that you turn to your communities. There are adults that need representation, probably in your own communities, children that need representation, and these sites here can lead you to organizations in your community that you can volunteer with. And last, I'd like to say that the way to help these separated families, which is still an ongoing crisis, as the panelists have mentioned, is to help the parents first. Because as Megan said, it's really hard for the children to express why they're here or be any help in their legal case. And so helping the parents pass their credible fear interview and bond out of detention will be the real way that these children can reunify with their parents, and they can continue on with their immigration case. So I think we're at time now. Thank you so much for joining. Like I said, I'm sorry that we didn't have enough time to answer questions, but on this last slide here, we do have our contact information. So we encourage all of you to reach out to us. And I think people can, drop off if you need to. It looks like we can go over time if people want to stick around to answer questions, if that's okay. We have a lot of questions on here, so if you have time, you can stay with us just a few minutes longer so we can answer some of these questions. And to all of you who need to drop off, thank you so much, and please reach out to us with anything you need. Okay, so I'm going to read out some of the questions that we have here from the audience. And our panelists can also look at the questions themselves. There is a box or a line that says questions, and you can pop the box out by undocking the panel. But I'll try to read out some of them. Okay, somebody has a question about Operation Streamline, so I think that's for Jody. Were migrants given an opportunity to make an asylum claim if they went through Operation Streamline?
Yes, if you went through Operation Streamline, you would still be eligible to make your claim for asylum. It would just be done after you completed the prosecution phase. So if you were given time served, that basically meant that you would just go to the court for that day and then be returned to immigration. They would still be eligible to apply for asylum.
Thanks, Jody. Somebody is seeking clarification as to whether people entering illegally and ultimately being prosecuted and sentenced if refugees are supposed to be excluded, how does Border Patrol or ICE determine those who are entering as economic migrants and those who are entering as asylum seekers?
The Border Patrol is supposed to do screenings with respect to individuals who have a fear of returning to their home country. So in each one of the arrest reports that are produced when the individuals are processed at the Border Patrol station, those are the Form I-213s. In each one of the I-213s, there's a series of questions that is supposed to be asked to every individual that's processed that has to do with whether or not they have a fear of returning to their home country. And most of the time, we often see arrest reports that don't include those questions, and we often see arrest reports that are cut and paste versions of the same arrest report. So for example, every single I-213 might say, I don't fear returning to my home country. I came to the United States to work in New York for 2 years. And we could see that exact same arrest report and the exact same I-213 in 20 cases in a row, including, 4-year-old children that claim that they came to the United States to go to New York to work for 2 years old. So I'm skeptical about whether or not that those questions for screening for asylum are actually asked every single time, simply because the documentation that we see from the arrest reports may not reflect that. But they're supposed to ask.
Thank you, Jody. And for those prosecuted, what is the level of representation they are provided and are entitled to have?
Okay, so because they are prosecuted and they are facing jail, they are entitled to have a lawyer by the Constitution. So every single person is represented. Even for the misdemeanor offenses, the federal public defenders are appointed to represent them. The level of representation is cursory in the sense that they are prosecuted en masse for the misdemeanor cases. If it is an illegal re-entry case, they are also appointed counsel. Lots of times that's a federal public defender or it could also be a CJA panel attorney. And those cases are felonies. They take much longer to go through the process. So the sort of, I guess, attention and time that gets spent on the felony prosecutions is a lot more in depth than the screening that goes on with the misdemeanor prosecutions.
Thank you. And another similar question is, if they are seeking asylum, is that a defense against illegal entry?
It's not a per se defense. I have had some attorneys, CJA attorneys, as well as public defenders, talk with me about presenting a duress or an incomplete duress defense in prosecution for illegal entry because individuals are asylum seekers. Quite frankly, it comes down to a matter of practicality, because if an individual is going to present that kind of defense, it could delay the amount of time that it will take for them to be prosecuted, which will mean that they will go into martial custody instead of going back with immigration so that they can move on with the immigration side of their cases. But I have had that discussed. I don't know of any cases that have actually taken up that offer, quite simply because of the practicality of the prolonged detention.
Thank you, Jody. And I think we'll give you a break now. Julie, are nationals of all countries subject to expedited removal?
So there are general exceptions for Mexicans and Canadians, but generally speaking, yes. Policy was previously not to subject Cubans to expedited removal, but that has since changed.
And are you able to give a quick explanation of what's in the new guidance issued by USCIS on Sessions' opinion in matter of AB?
Sure, so I can go over that briefly. So the guidance goes into sort of explaining the dicta of Sessions' opinion, in that asylum officers are instructed to look at domestic violence and claims, really examine whether or not these social groups are what's called under immigration law cognizable, meaning recognized under immigration law. Whether the persecution by private act constitutes a particular social group. As a particular social group, which is one of the reasons for persecution that a person can get, is a very nebulous. A lot of case law defining it in matter of AB is just recent BIA decision about that, or AG decision rather. So it really goes into looking at the government involvement or lack thereof in this kind of persecution, defining the social group in terms of, or rather not defining this in terms of whether or not private actors are involved in based on the persecution the person suffered, things like that. The other really interesting, and I mean, I guess it in AB basically said that people who are victims of gang violence, and that's not law, since it's spawned by the immigration but there are ways to instruct immigration judges and the asylum officers to interpret that, essentially reach that. One other thing I want to note about the asylum officer, or the asylum officers, that they also ask asylum officers to take when determining the credibility of these. Like Jody was talking about authorization, or have the right to do that. And what the asylum officers are instructed to do without authorization, that's part of their credibility. So the implication, of course, is not break the law. A true asylum, and the people who are crossing the border are economic migrants claiming asylum because they got caught. So that's tied into, they have tied it into credibility to get a that people who enter that asylum. So it's obviously out on the ground, very development, I think.
And I think we're losing, you're cutting out, Julie. And I think the last part that Julie was mentioning was the idea that that officers can determine somebody not credible if they enter outside of the port of entries. If they enter unlawfully, then they can the asylum officers can make a negative credibility determination. A question for, I'll ask this of Jody, I think. The separated parents were given a credible fear interview after federal prosecution, after they had returned to the CBP station. Do they stay there during the credible fear process, or are they transferred to ICE detention and wait there?
No, after they return to the Border Patrol from being prosecuted, then they are held until Border Patrol can find a bed available in ICE detention. So ICE is interior enforcement that actually runs the detention and deportation of aliens once they're in the United States. So what I have seen is that they normally will wait about 3 or 4 days after prosecution until they get put into a facility. Sometimes it'll only be 1 or 2 days, but they'll wait with Border Patrol until they get a bed. And then once they get at the ICE facility, whether that is an ICE-run facility like the Port Isabel Detention Center or one of the many, many prolific private prison companies that also house ICE detainees, they'll wait for their credible fear interview at that facility. And the timeline to get the credible fear interview can be anywhere from 2 to 4 weeks.
Thank you. And have you seen any grants of re-interviews for parents who were separated from their children if they got a negative credible fear finding?
So we're seeing a lot of negative credible fear findings based basically on what Julie was talking about with respect to the guidance the asylum officers have been given regarding Attorney General Sessions' opinion in matter of AB. So we're seeing a significant, an unbelievable number of negative CFIs. And we have requests pending for re-interview in a lot of cases. The asylum office has not responded to our request for re-interview yet, and we'll wait to see if they respond to that first or if the deadline to reunify them with their children comes first. But we do have those pending. In the past, I can tell you that it is generally difficult to be able to get a re-interview request granted by the asylum office unless you have some sort of new evidence or information that was not previously provided to the asylum officer that is significant enough to make them change their mind. But we're hopeful in the cases that we have filed so far, simply because the interviews are very cursory. They were done quickly. Our clients are under extreme mental distress. They really can't focus on their cases. They're much more concerned about getting their children. So we've made requests in a lot of cases. I don't know the number, but a whole lot of them.
And somebody is asking for clarification on whether parents are currently being separated from their children.
Currently, they are not systematically separating parents from their children because they are not systematically prosecuting parents for illegal entry. There are exceptions, and that is if they choose to detain a father that has come with a child, they will separate the father and the child because there is no facility that holds fathers and their children. There's only family facilities for mothers and their children. And more importantly, to answer your question about whether or not there are people that are separated from their children, absolutely. We believe that the number is somewhere around 2,400, 2,500 parents. Some estimates are up to 3,000 in terms of the number of children that are still separated. And those individuals have not been reunited yet. And that's something that we still work on a daily basis. And it's a trickle effect as to the number of people that actually get reunited. There's a significant number of parents and children that are still separated because of the policy.
Thank you so much. So that's it for our additional 15 minutes. I want to thank Jody, Julie, and Megan for taking time out. I know they're really busy down at the border, so we really appreciate you being on. And to all of those who were on the webinar, thank you so much. And please feel free to reach out to us with any questions. Thank you.